be here to talk about such a great revolutionary technology, one that has the potential to change our technological future. Today you're going to learn about initial coin offerings and IP protection for blockchain innovations. And to kick it off, my name is Giovanna Fessenden, as said, and I'm an IP attorney with Hamilton, Brook, Smith & Reynolds. And this is Steve Galebach, who is counsel to Block Mason. And he's going to kick it off to talk about the security, how you navigate the securities landscape. Yes.
Thanks very much, Giovanna. Okay, so it's been about a year now since I first heard about and got involved in the Ethereum ICO world. Compared to most legal fields, a year of experience would be minimal. In this field, it's about as much as anybody has. So it's also such a rapidly developing field. I'm going to be challenged to give you the basic contours of the securities landscape just in the US within the allotted time. So I'm going to move pretty quickly through that landscape. Block Mason was the occasion for me to get involved in an ICO that took place in September and October of this past year. I had been working with the group since early last year. First with a plan they had, which I had to advise them was a brilliant business plan, but from a legal perspective, it constituted an offer of securities, which could only be done publicly with a registered offering, which is immensely complex and expensive, and to this date still hasn't been done, as far as I know, for any ICO token. I don't know of any that's registered as a public offering to be held by the general public as a security. So what happened was the Block Mason team adjusted their plan over time, and when the first SEC pronouncement on Ethereum ICOs came out on July 25th of last year, Block Mason was in a perfect position to proceed with their plan because they had designed a product and a service with a token as a license to use it in a way that under the SEC decision and the Supreme Court decisions that were relevant was not a security, a token that was not a security, and this could be offered publicly without securities regulation in the US or in most other parts of the world. So what is the test for whether an ICO token is a security when offered, let's say, either privately to accredited investors or publicly to the general public? I'm going to go quickly through this. Howey is a Supreme Court case, SEC v. Howey from 1946. 3 criteria for an investment contract is one of the categories of security under the securities law, in addition to stocks and bonds and so forth. It's an investment of money. In an Ethereum ICO, you're investing typically Ether, sometimes Bitcoin, once in a while fiat currency, but in any case, that's an investment of money. In a common enterprise, some Ethereum ICOs are a common enterprise where everybody shares in the economics of the enterprise. Some of them, as I'll explain, are not. And finally, third, with expectation of profits to be derived predominantly from the efforts of others. Okay? So notice that in the Howey case, the third prong was profits to come solely from the efforts of others. That would be the efforts of the offeror, typically, the company that you're investing in. With Block Mason, they had designed their token as a license to use their credit protocol product, which already existed in beta stage as of the time of their ICO, so they could market to potential buyers, not based on this is a great investment, not based on we're a great team, you should trust us, not based on the value of the token is going to the moon and you'll all be driving Lambos, which is the typical hype in the ICO world, okay? But instead they could market it as you should make your purchase decision based on your evaluation of our product and how you want to use it and how you want to develop on top of it using our APIs, with the code accessible on GitHub and with a beta version accessible and testable, usable, okay? And then within 2 days after they concluded their ICO and issued their tokens, to the purchasers 2 days later. Credit protocol went up on the Ethereum mainnet. It had been on the test net before, so the tokens actually were usable. So the value of those tokens, okay, when you look at the Supreme Court case of Foreman from 1975, what we focused on with Block Mason was a purchaser motivated by a desire to use or consume the item purchased. In other words, use the token to have access to credit protocol, use credit protocol, build other DApps, distributed applications on top of credit protocol, and that's what we rested upon, okay? There's been a lot that's happened since that ICO finished in mid-October, so I'm going to go rapidly through the developments. Okay. First, in October, we had the Commodity Futures Trading Commission say that ICO tokens may be commodities or derivatives contracts, okay? Their main concern was fraud. Possible impact could be on SAFs, which are simple agreements for future tokens, which is what, as you may know, ICO companies typically sell privately to purchasers before the public sale begins. Okay, CFTC actually hasn't done much. So that, at this point, is one of the smallest landmarks on the landscape. But then we had last year's new chairman of the SEC, Jay Clayton, say, if we could go back just one moment, that I've yet to see an ICO that doesn't have a sufficient number of hallmarks of a security, okay? I've never seen a token yet that didn't look like a security to me. Now, keep in mind, that was November 8th. That was to a conference of securities lawyers in New York City. And although he's the chairman, he's one of 5 commissioners. So he really doesn't have the solo power to have the SEC come down with a use that all ICO tokens are securities. And in fact, the SEC hasn't come out with such a pronouncement. But, as we'll see what it has done, you had December 4th, an SEC enforcement action. This was over a fairly egregious case. We're still waiting for an instructive case to come out from the SEC that would say, here are the types of tokens that are not securities and all other tokens are securities. Still waiting for that. There was a cyber unit formed in the SEC in September, and the special focus is on scams and fraud, okay? But we have not heard any more discussion of the Howey test from SEC staff in any public pronouncement since July 25th of last year in their initial statement that concerned the DAO or DAO ICO, which was famously hacked to the tune of several tens of millions of dollars worth of ETH. So now, December 11th, 2 main developments that day. One was an enforcement action against Munchie Inc., which was doing an ICO based in California. Key finding was that no one was able to buy any good or service with the Munchie token throughout the relevant period, okay? So they said that their token was a utility token, that it had utility, but at the time they issued it and for the time thereafter, it wasn't useful for anything. I should mention that back in August for Block Mason, I prepared a 31-page opinion letter, legal opinion, analyzing the state of the law, half a dozen Supreme Court cases, including the Foreman case that you saw there, and explaining why their token was not a security. And the concept I used was product use token, with the emphasis on you have to have a product, has to be at least at the beta stage so people can decide whether to purchase tokens based on what they think of your product, and the token has to be actually usable for using the product use. That differed from a lot of the terminology. Typically, the major go-to law firms, US, the ones with 1,000 lawyers nationwide or worldwide, have in the past, and still largely do, use the term utility token, that if it has utility, then it's not a security. I didn't want to go that way just because if it doesn't have utility, it's not going to be found in the real world of economic profit making. Okay, so the other factor in Munchie was that they were targeting in their marketing the crypto community and not the community of potential users of their token. Okay, so now we go on to same day, December 11th, we heard again from Jay Clayton, this time in a formal statement. He said just because it's a utility token doesn't mean it's a non-security token. He gave an example of something that might not be a security, which would be, let's say, a token for a Book of the Month club, okay? So you sell the tokens, and the Book of the Month club blockchain company uses the proceeds to buy books, and then the tokens determine who can get the books. He gave a counterexample of, let's say you have an ICO for a publishing house that hasn't even been built, and the author's books and distribution networks are all to come. Now, in fact, the second one does frankly describe a fair number of ICOs where even to this day they don't have anything built on the blockchain, okay? And they marketed just based on a white paper and an idea. Unfortunately, the first example isn't all that useful since it's a century-old phenomenon of the Book of the Month Club that existed when I was a kid, and it would be helpful to have, maybe an example of something that's a little more cutting edge so that we can know that there is something you could actually do on the blockchain that you could tokenize in a way that's not a security. We do not have that yet from the SEC. So now we go on to next development, which was just last week, 8 days ago on Monday in San Diego, California. There was another securities lawyers conference, okay? And at this one, these are Clayton's words. Simple, stern, market professionals, and he means especially lawyers, okay, are going to be held accountable, all right? Accountable to what? Well, he doesn't like the fact that there are ICOs where the lawyers appear to be assisting promoters in structuring offerings of products that have many of the key features of a security offering. Call it an ICO, which sounds pretty close to an IPO. Now, interestingly, the Supreme Court decisions and SEC decisions make it very clear that you don't go by the terminology, you go by the economic reality, okay? So the fact that ICO sounds like IPO should have exactly zero relevance to a legal analysis. Unfortunately, that doesn't seem to be the case in the mind of our chairman of the SEC, and we have to live with that and deal with that. Okay, and then final paragraph here. He talked about where lawyers appear to have taken a step back from the key issues, including whether the coin is a security. And then they provide it depends equivocal advice, and then the ICO proceeds. Okay, the only catch is there's nothing either in these quoted words or in the rest of his speech that gives any idea of what might make a token not a security. So at this point, until there's further guidance, everyone in the ICO world is in considerable uncertainty about how the SEC will eventually come down. Now, I do understand that there are talks going on at the SEC staff level about this very important question of what type of token is a security and what is not. It's probably going to take quite a while until that deliberation produces some useful guidance for us within the US who are considering ICOs, not just Black Mason, which did one, but my other clients and the other clients that are going to other lawyers and other law firms. In the meantime, and I should mention two other things that have happened. One is that in Massachusetts, where we currently sit, the Secretary of State became the first, as far as I know, state securities regulator to take a decisive public action against an ICO. That was toward an ICO called Caviar. It was pretty heavily, I think, advertised at some meetups, both in Cambridge and in Boston. So even though the ICO was officially done from the Cayman Islands, which is a hospitable and friendly jurisdiction toward ICOs, Caviar was held accountable for its marketing in Massachusetts, and that was enough to bring Massachusetts regulatory enforcement action down upon them. And then there's this morning, okay? I said things happen fast. It's hard to get through everything, especially when something else gets added at the last minute. Arise Bank in Texas had a goal of raising $1 billion for a distributed architecture, new technology bank. And they were doing really well. They had gotten up to $600 million when this morning the SEC announced that they had just shut them down and put them in receivership, appointing a receiver to run them as if they were in bankruptcy, okay? So that's the latest. Just real quickly, where we're at, what are the paths forward? There are several paths that ICO companies have been tending toward as the regulatory environment has gotten tighter and as the uncertainties produce more drastic consequences. One is more and more ICOs are relying on private pre-purchases of tokens, and some of them exclusively on that, so that the private purchases are not only pre-ICO, but they're instead of ICO, and then through various means they will get listed on exchanges and can be purchased by others than the favored few, private purchasers, okay? In order to do that, there are two ways to do it. One is to accredited investors only and use only private marketing, not public general advertising. The other way, which was enabled by the Jobs Act several years ago and an SEC implementing regulation that came into effect just a year or two ago, is to do a general solicitation. But when you do that, in other words, to the public, advertise, over the internet, worldwide, whatever, you have to make sure that you use reasonable steps to determine that all the purchasers are accredited investors. I mean, typically that they have $1 million in assets other than their primary residence, or that they have 200,000 annual income. Okay, that's one way, which is accredited investors. Another way is to move to another jurisdiction. There are other jurisdictions that have recognized that ICOs are a useful means of honest, productive capital formation for highly valuable, cutting-edge new technology. And there are jurisdictions whose securities regulators have begun to take the approach that they will screen for scams, they will screen for fraud, and they will greenlight ICOs that have real value and that are building or real product services networks that are usable through their tokens. Interestingly, Germany, their financial regulator is also their securities regulator, abbreviated BaFin. They issued a pronouncement just a couple months ago that ICO tokens are not securities. Now, it still remains unclear exactly what they will do with them. They call them units of account, and exactly that means lighter regulated than an IPO, but nobody knows yet exactly how light the regulation is because they haven't yet finished examining and greenlighting an ICO, as far as I can determine. So those are the basic paths. Other than that, we do have Supreme Court decisions on what is and is not an investment contract. And at some point, ultimately, these cases are likely to be decided at the Supreme Court level. The Supreme Court hasn't been shy in the past in taking investment contract cases. They've done it about a half dozen times, on average about once a decade, okay? They're about due for another one. And obviously, it needs to be the right case. Bad facts make bad law, but a well-constructed ICO could make, very good law. So with that, I will turn it over to Giovanna with just one quick additional word of introduction. One of my tasks for Block Mason was to do a nationwide search for a patent lawyer who would be the best for them, namely blockchain patent drafting experience. And after doing a search, interviewing people who were at the highest level in the patent law department at some of the biggest go-to firms for Ethereum ICOs, I had to tell my clients, there's somebody better than that right here in Boston. That's Giovanna.
Thank you. Thank you, Steve. Now, can you hear me? Yeah? Okay. Very nice introduction. Okay, so today I'm going to be speaking about IP protection for blockchain innovations. And you will learn about the origins of blockchain technology, about types of IP protection available for blockchain companies, and about the key goals for blockchain companies, as well as the pitfalls to avoid. Just a little bit about my firm. I'm with Hamilton, Brook, Smith & Reynolds. We're, excuse me, an intellectual property boutique. We have offices in the Seaport and in Concord, and we have patent attorneys and technology specialists ranging all areas of technology, including biotechnology, medical devices, computer technology, and my particular expertise is in computer science. I studied at Smith College. I worked for a little while in the industry as a programmer. I worked abroad in Switzerland for an NGO, maintaining their networks and assisting them with their databases, online databases. And I also worked at Harvard as a programmer. I went on to law school to help protect software innovations and try to help promote technological advancement in the software area. And I found myself in a blockchain. I have expertise in many areas of software, but blockchain is one of my particular expertise. I wrote my first patent application in the blockchain space about 3 years ago, and that client went on to have a very successful ICO. And I've done a TEDx talk on the blockchain revolution. And I want to let you know that this should not be, Steve's talk nor mine should be considered legal advice, with that caveat. So moving forward, let's begin to where it all began, with the blockchain. So the blockchain is the first commercial implementation of the blockchain is the Bitcoin blockchain. And while Bitcoin is interesting, what's really fascinating and revolutionary is the blockchain that makes Bitcoin work. Now, the blockchain is composed of several different old technologies. It's composed of a distributed peer-to-peer network, of consensus technology, of the proof of work, of computationally, cryptographically secured backlinked list of blocks. And all of these technologies fused together is what makes the blockchain so interesting, so revolutionary, that it has the potential to change our technological future. Now, what types of intellectual property protection are available for blockchain companies? You have patents, which cover ideas, a technical implementation of your blockchain platform, or some innovation related to your blockchain company. Trademarks protect the name. Block Mason, for example, is a trademark that is a source identifier and helps identify a company or a product. And you have trade secrets, which protect the know-how, the computer software source code of the company. And you have copyrights, which protect the source code as a literary work. Now, I have open source software in here as a component because it's a very large component of all of the major blockchain, commercially available blockchain. It's available. Bitcoin is open source. Ethereum is open source, and as well as Hyperledger. And Ethereum, for example, requires dApps and decentralized apps running on its system middleware to also be open source and to be licensed under a form of the GPL. So this is something I'm going to talk a little bit about in a moment, but it's something to be sensitive about because in some respects, open source licensing can erode your intellectual property rights, and it's something you want to be sensitive to and be aware of. But it's also something that you can leverage and can strategically help increase interoperability and really help the market share of your company. So you want to balance open source licensing, and you just want to make sure it's a conscious, deliberate, strategic decision. So intellectual property protection is a ripe area for blockchain companies. Right now, we're at the infancy. There's not a tremendous amount of patent activity, but there's been an uptick in patent filing. And so we want to file patents. You want to file patents to protect your blockchain innovations, and you want to balance the effect of open source licensing because it has the potential, like I said, to erode your intellectual property rights. To give you an example, for the Ethereum blockchain, they are requiring middleware to also license their dApps as under some form of the GPL. And you can check this out on the GitHub site under licensing for Ethereum. But it just they have a white paper, and they describe that they really, they're going to push this types of licensing. So if you open source license your software, you potentially give a license, a patent license, to that implementation. And that's just something you need to be aware of when you're going into the space. So we've seen, like I mentioned, we've seen an uptick in patent filings related to blockchain innovations, and it's growing. And there are many reasons to file for patent applications. It's not just for enforcement. I mean, patent applications help. A patent will help protect your market share. It will help deter competitors from going into that space. And it's also like a badge of innovation for your company. So there are many reasons for pursuing patent protection, but it also helps increase the value of your company, even at the ICO stage. And I can't overemphasize enough how important it is to file early. So even before you start thinking about the ICO, or as soon as you start thinking about the ICO, you should meet with me or someone at Hamilton Brook or some patent attorney and work out a strategy for filing for patent protection. You want to file as early as you can, and you can use your patent application as a basis for your technical white paper. And the patent application, a well-structured patent application, focuses on the problem-solution approach. So your technology is solving some type of problem in the industry, or technological problem, rather. And that's something that is laid out well in your patent application. And I've had clients just repurpose their patents that I filed for them into their technical white paper. And so that is something that is important to bear in mind, that you want to file your patent application because it helps protect your technology, and it potentially can help increase the value of your company. Other things to consider when you're doing your ICO is you want to make sure that at least the successful ICOs you want to make sure that your token is integrated with your business model. So your token should be like a license to your software, a license to use your system. I mean, that's typically where we would want to see where an ICO might be appropriate. And you want an accomplished leadership team, technical team, that can go around to the various conferences and advertise your product and your offering. And you, of course, want legal compliance. So you would meet with you'd meet with Steve or someone like Steve to help navigate the securities landscape and make sure that you comply with all of the security regulations, and in particular the Howey test, and make sure that your offering is prudent and complies with the law. So let's talk about some of the key goals for blockchain companies. You want to attract investment and ensure future earnings for your company. So through the patent process, that is something that will help feed that goal. Patents help attract investment. It helps an investor feel secure about their investment for your company. And you also want to protect that intellectual property that you've created from devaluation. So open source licensing can potentially devalue your intellectual property, and that's something that you can balance, and you can use open source licensing actually strategically, if you do it appropriately, to help increase the value of your company through different types of licensing schemes like dual licensing, where you do proprietary licensing and open source licensing at the same time. So you want to control those contributions to the open source community and not just inadvertently create an app on a blockchain platform which causes your software to automatically become open source. So that needs to be a conscious decision. And of course you want to avoid exposure to copyright and patent trolls. So that's something that we do at Hamilton Brook. We can make sure that you have, to try to help you make sure that you have the freedom to operate. And there's definitely a lot of intellectual property out there that you need to be sensitive to, and that's something that we can help you do. And with blockchain, with all the major public blockchains, there are definitely security issues. Just coin check just last week in Japan lost $500 million to hackers. So it's definitely an area that is very vulnerable to security issues, and you need to be sensitive to that and make sure that that is something that your company addresses. So, to ensure to ensure that your company is a successful product, you want to make sure that you file for your patent applications, and you want to make sure that it helps attract and help secure future earnings. You want to make sure that your intellectual property also ensures the freedom to operate for your company. So with these goals in mind, you want to make sure that I urge you to contact legal counsel. For example, you should reach out to Steve to move forward with your initial, to your ICO. And you should, I would love for you to come meet with me so that I can help provide you with legal guidance to ensure that your intellectual property portfolio maximizes value for your company. So thank you. And I look forward to partnering with all of you and being helpful. So with that in mind, with the theme of being helpful, we can proceed with the question and answer session, okay?
Yes.
So, as an ICO company, if you do a private sale to accredited investors, how can you, or what's the best process then to list on a public exchange following a private sale?
Okay, so what you're doing in a private sale, typically you're selling a SAFT, a simple agreement for future tokens. You have a date in the future when you're either going to do your public sale ICO, or in the instance you reference, you're simply going to issue the tokens at some future point. And you start approaching exchanges and go through their process for getting listed on an exchange. And once you get listed on one or more exchanges, then you can issue your tokens, and they're tradable. It's the same thing that happens in a typical ICO where there's been a private pre-sale period. And so you have accredited investors who are purchasing typically SAFTs. They're going to get their tokens at the same time everyone else does at the conclusion of the public sale. But there's not a public sale. So it's only the private purchasers who are involved.
Yeah? Yes?
Yes.
Stephen, you used the term, it may take some time before you get some guidance from SEC. Is there any more specificity that you could sort of advise, timeframe, window, typical behaviors in the past?
Yes, I could. So the question is, what's the typical time frame for the SEC to deliberate and come to a decision? The closest analogy I could draw is, let's say, when a company goes into the SEC with a, let's say, difficult question, or a question in which the state of the law or the regulations or court precedents, whatever, is not entirely clear, and they ask the SEC for a no-action letter. Okay? That would be a letter from the SEC saying that if company X goes ahead and does what it has proposed, and does it in the way in which it is proposed, then the SEC will not take enforcement action against company X. No-action letters typically take at least half a year, often more than a year, and anything having to do with ICOs promises to be on the high side of complexity and duration.
Yes?
How much activities are you seeing on the application of blockchain in the healthcare industry?
So the question is, how many applications are you seeing in blockchain space related to the healthcare industry? From my perspective, I would say a good portion of patent activity relates to the healthcare space. It seems to be ripe, full of problems, and there are lots of different types of blockchain solutions that have been that companies are pursuing.
I would second that. I have a client that is exactly in that space. And yes, it's low-hanging fruit to design improvements to the current state of healthcare data.
Yes? Yes.
Curious, what are you guys seeing in terms of terms around some of the pre-sales for things that might be considered a part of normal equity purchase agreement, so kind of governance, so things like information rights, or just articulations of governance of a particular project or company. Are any of those things starting to be formalized or standardized, or still kind of all over the place from project to project?
Okay, so the question is, in the context of, let's say, ICOs, are any of the corporate governance provisions that we see in other areas coming to bear on ICO companies? That's still a developing field. I've seen examples, let's say, of companies that sell SAFTs, but they have a contingency provision so that if they are not able to proceed with a public sale, the SAFT holders would get a share of equity instead of getting tokens. And it's certainly possible to negotiate for various sorts of oversight rights and limitations on, let's say, use of proceeds, which might be one of the most useful types of provisions, so that investors are assured that the proceeds will be used to develop product, rather than whatever.
Yes?
What's the ballpark cost to pursue and implement a ICO?
The question is, what is the ballpark cost to implement, to launch an ICO? I'll just to take a little bit of this question. My firm doesn't do ICOs, but I've worked with other attorneys that do, and it's a very wide spectrum, but these days you're looking at up to $1 million. It can be, but there are more cost-effective solutions. I'll let Steve speak to that, but Steve handles ICOs in a much more economical manner, and he's definitely on the prudent side, so I would recommend going with him, not only for economics, but also because he makes sure that it's done properly.
One thing I'd add, haven't had any $1 million engagements, but I also understand that that's realistic in some ways, because it's a high-risk activity. And basically, one of the tasks that a lawyer can do, short of, let's say, issuing an opinion letter, as in the Block Mason case, which then they published, I think that's a useful thing. I think it would be a good development to have more published opinion letters, because that would help over time to develop standards of what holds up under scrutiny, okay? So that the SEC looks at this, that, and the other ICO, which was done on this, that, or the other theory explained in a published opinion letter, and has not taken enforcement action. That in itself can be not reliable guidance, but at least more guidance than what we're getting at the present time from the SEC. But short of opinion letters, lawyers can be very helpful in giving advice about how to market, how to design a token structure that makes sense in connection with a product or service, a network. And basically, given the enforcement actions of the SEC, you're really talking about a minefield, and you just need someone who either knows where the mines are that have been identified so far and where the other mines are likely to be, which will be, which will come to light in the future with future SEC enforcement actions. It's a matter of minimizing risk. There's no such thing as zero risk.
Yes.
Two questions. One is, I read both your papers, and they were great. Block Mason, did they ICO in Massachusetts? I know they're Massachusetts based. Did they, register? I can't remember that part. They registered and took U.S. investment and all that. I can't remember.
Okay, so the question's about Block Mason and where they registered and where they accepted funds from, purchasers from. Okay, so actually they're a Cayman Islands corporation, and all of their development was done offshore. That was at a time when there were tax reasons for developing offshore, and that led really dozens of ICO companies to move to the Cayman Islands, which has a fairly mature and dependable legal structure and has a business structure already, with process for quick work visas. Block Mason's ICO was open to purchasers from anywhere, any country, with the exception of China.
In part two, for the technology people here, who are looking at this, what can we do to, move this along? You said go for, an opinion letter with our lawyers. Is there something we can do as a community? I know there's some other people who have decided to raise more funds, but, how do we go educate, or any recommendations? Considering the last 3 blockchain events I've gone to, 500 people in one in Cambridge, 350 people in another one in Boston. Seems to be a hot topic. And I would think we could do something as a group. Any ideas?
Okay, so what can the tech community do to move things along? One thing I'd suggest is by analogy to what's happened traditionally in capital formation in the tech community, where the tie into venture capitalists and private equity is very important, especially as ICOs have moved toward private sales to accredited purchasers. There's a lot of opportunity for that same sort of interaction between tech community and venture community to have an impact in the ICO space.
I think one other thing the tech community can do is comment on what ICOs appear to be authentic and proper, and this is a real company with a real product, and then the ones that are not, and for them to make it clear, which is a worthwhile ICO and which isn't, to perhaps self-regulate so that if this information is out there, then perhaps that the regulatory bodies will not come down as hard if it appears that the community is self-regulating itself, like the Motion Picture Association did, for example.
I'll add one point onto that suggestion from Giovanna, which is I think is a really good one. I mean, here we are in Massachusetts, okay? So it's not that hard for the tech community. We have a tremendous tech community centered on universities, and we have regulators in our government who respect those universities. It wouldn't be impossible, for somebody like Secretary of State Bill Galvin to look at what types of ICOs are not scams, not frauds, economically beneficial, socially beneficial, improve the economy of the Commonwealth. And if a state took the lead in doing that, that might give some ideas to the SEC.
Yes.
Yeah, so I guess tying on to that, are you seeing a lot of any early stage funds or indications some of the early stage funds are using ICOs to raise the funds to then invest in companies in ICO? That would be a way to kind of allow a fund structure to kind of do the traditional fundraising with the SEC, but then have a capability to accept crypto as a liquidation event. Are you seeing that happening in Massachusetts now?
Okay, so let's make sure we recite the question back, and I want to make sure I understand it. Okay, so have we seen any ICOs that are raising funds to plow into basically ICO investment funds. I vaguely remember seeing some things like that, but I am not really familiar with details of any. Giovanna?
I'll say the same. I think I might have met somebody that was interested in doing something similar, but I don't know if it's actually been implemented. Yes.
Can you speak to your experience with regard to blockchain-related patent applications in the patent office, the frequency of subject matter or one-on-one rejections you've been getting, and any strategies that you're employing to avoid those?
Right. So to avoid 101, the question is, are there any, can I speak to the different strategies that may be used to help overcome subject matter eligibility rejections from the patent office related to blockchain innovations? And I'll say that one of the most important things when you're creating a software application, patent application, is to make sure that that it's clearly structured, that you have a problem, a technical problem, and you have a technical solution to that problem, and that it will help ideally improve the performance of the computer or of the blockchain or of the technological platform. So you want to make sure that there's a clear technological improvement, and if you have that built into your application, then you are unlikely to suffer from subject matter eligibility rejections. So it's about positioning your patent application appropriately and to make sure that you have good technology that you are actually pursuing. Yes?
What type of insurance would you recommend for companies who are in the business of applying blockchain to any industry, financial services or healthcare or anything else, or telecom?
So the question is, what kind of insurance would you recommend for blockchain companies? And I don't have any particular experience in that space, but I would recommend a lot of insurance, as much as you can.
Would cyber liability be the right insurance?
Well, you mean for the securities issue? I mean, for security issues, or for?
Any type of risk management. I know E&O is going to need it.
Right.
So for risk management, cyber liability insurance be the right insurance? Do we have an insurance that covers all of the risk for blockchain?
It's a good question, and it's one that I don't have an answer for. Do you have any experience in that space?
I don't. Because of the high level of uncertainty, combined with a fairly high level of risk, I would expect insurance companies, to the extent they develop any products, would be charging a very, very high price, because it's only over time that they'll really know actuarially, how to price it.
It took the insurance industry a long time to come up with finally cyber liability insurance. But even now it has so many loopholes that if you have that insurance, you're still using it.
So the best insurance for an ICO is to have a very good audit done of their smart contract, and typically more than one audit done of their smart contract, because as people probably understand, the blockchain is designed in a way that is unhackable, or at least not hackable with current technology. But there have been famous hacks, including the one Giovanna mentioned, which happened at more of the entrance and exit points, at the exchanges, at the ICO point of the blockchain. So from what I've seen with my clients, it's been very important to have a high-quality audit done, and having more than one audit done has been a good idea.
Yes.
We've talked about utility use of tokens for products. We've talked about tokens as equity, which is pretty much a no-go line so far. What about tokens as control? Part of the promise of blockchain was you could vote your token. Ethereum itself, we were going to have these massive distributed autonomous organizations, unknown owners voting on them. Any progress there?
I could talk to that. Okay, so the question is, how about tokens as a means of control or an instrument to enable aspects of control over an organization, over decisions that are made. So the DAO, had that type of participatory control as a major feature. And at the time they designed that, I guess a couple years ago, I'm sure that seemed like a very good way to avoid being viewed as a typical corporation, fitting into a mold with securities. But what the SEC did with that participatory control feature was they said that that actually adds to the security aspect of the token, okay? Because just as a shareholder would have participatory rights, so a DAO token holder had participatory rights. When you first mentioned the word control, it brought to my mind another type of control, which is that a token can be used to control access, okay, to a network. I mean, the Ethereum network, especially since the CryptoKitties ICO of a couple months ago, has rather famously had congestion and slowness problems. And you then incentivize people, say, to build side chains, to build various solutions to those congestion problems. And tokens can be a control mechanism, okay, for network flow issues. Credit Protocol used their token also to control number of transactions per time, per unit of time. And a token can be used as a control in that way. So there are a lot of technical control in network usages that I would say make a token much different from a security. But all of the more corporate participatory control decision-making aspects of a token would make it more like a security.
Yes?
I have a question regarding IP protection regarding certain blockchain. So if we take, for example, Rapid blockchain, build on top of it, like to modify it and make our own blockchain, is it still IP protectable if the base version is Rapid blockchain?
The base of the blockchain is based on what?
We take the blockchain.
Like what blockchain? Like Ethereum's client? Or
Kraken.
which one?
Kraken.
Okay.
We modify it,
Mhm.
and afterwards it is still IP protectable if we modify certain blockchain and make our own.
Right. Okay, so the question is, if you take an existing blockchain like Rafi and modify it, is it still ripe for intellectual property protection? Okay, so there's, the answer is yes and no, it depends, It depends on, I'm not familiar with the license for Rafi, so I don't know exactly what the license is there, so that could be controlling. But patents, for example, they cover ideas. So the Rafi is providing code for a particular implementation of that blockchain, and a patent would cover many different types of implementations, not just that specific source code that you started from. So a patent would cover some kind of innovation that you're using, that you're making with your blockchain technology. And so it would be separate, I would think. But you would want to be careful about any of the licensing requirements that are associated with that private blockchain that you are using as a basis. Yes?
So the applications that you produce based on the blockchain?
Yes.
Different applications. So how likely is it, how easy is it to patent those? You're not making
Like
changes to the blockchain itself, but you're basically an application on top of it.
Right. So as long as you are, the innovation in your DApp, in your application that's going to be running on top of the blockchain, as long as it's new, it's not obvious, it's useful, and it is solving a real technical problem, improving the performance of the computer, or creating a real technical improvement, then that would be something that would be ripe for patenting. And so that would, it definitely is something that could be pursued. Yes, Ed?
The original impetus behind ICOs were wide distribution of tokens so that people would experiment at a low cost and maybe improve the blockchain. But the first two of your options don't really meet that goal because you're limited to 198 accredited investors. The third one, moving to another jurisdiction, really don't you have to actually be, before you even begin any development or do anything, you have to be incorporated in that jurisdiction. You can't leave that jurisdiction. And you can't have any owners. For instance, I'm looking at the Caviar case in Massachusetts. The majority owner was in Brookline, even though he incorporated in the Caymans. So you really, if you think about ownership, you wouldn't want even an investor from Massachusetts. And you want to be you basically want to pack your house up and leave. Is that the way you see that third option?
Okay, so question about the jurisdiction that you conduct an ICO from. Number of different factors play into that. Caviar case is a good case, instructive to look at. The Massachusetts enforcement action was not based primarily on a majority owner living in Brookline. It was based on that particular person and others involved with the effort marketing to Massachusetts residents. So the securities laws are going to be enforced primarily in two directions. One, and primarily, is who are the tokens being sold to, okay? Because each jurisdiction, the United States as a country, and each state has an interest in protecting its citizens and residents from either a scam, fraudulent activity, or a sale of a security that's not registered, okay? The second focus would be on where is the ICO conducted from. So whatever jurisdiction it's conducted from, that jurisdiction's securities laws and other laws will also apply to that ICO. But now let's take a counterexample. Okay, if somebody comes into Massachusetts from, let's say, China, okay, has a great idea for an ICO, together with some other, developers, entrepreneurs, designs an ICO. Well, that ICO is not going to be governed by Chinese law because that person is a Chinese national. It'll be governed by Massachusetts law, by U.S. securities law, and potentially by the laws of the countries and states where the tokens are sold. But if, for instance, that ICO were to exclude China, okay, as a place where you can buy tokens from, simply exclude that market, have a requirement that you can't buy these tokens if you're a citizen or resident of China, then the involvement of a Chinese national would become, as far as I can see, pretty much irrelevant to the legal status of the ICO, unless the Chinese government decided to take some extraordinary action that hasn't been done yet.
Isn't that really what happened with Caviar? Didn't they not offer their tokens in the United States?
That's correct.
They excluded the U.S., but they had been marketing in the U.S., including in Massachusetts, and one of the premises of the enforcement action was that it was easy to circumvent their exclusion of U.S. citizens and residents. And I believe the enforcement action actually recited that in the course of the investigation, the investigators had been able to sign on to the white list or whatever in various ways, even though they were doing so from the U.S. So I believe what becomes important going forward is ways to use probably the blockchain to verify and authenticate both perhaps the accredited investor status of a purchaser and also the citizenship and residency of that person. Because after all, when someone buys tokens, they typically do it from an address on the blockchain identified by their public key, okay? And so if that address can be pre-qualified through a verification
Beyond that,
process.
do you have any developers, I mean, you develop offshore, that's a key part of it as well. You can't really have people working for you in this state, because then, you run afoul of these issues.
Yeah, that's a good question, Ed, both for tax purposes and for regulatory purposes. But there are different types of employees doing different things. So let's say you're an offshore ICO, okay, and you're excluding the US marketplace. You certainly don't want to have your marketer be in the US. But I don't believe that having your law firm or your accountant, various professionals like that, is going to bring you under US jurisdiction. I can't give you legal advice on that, but typically in the past, offshore companies have felt free to go to US lawyers, US accountants, US tax preparers. That used to be a bigger issue in tax law before December 22nd when the new tax law was signed, and basically the advantages, tax advantages of offshore ICOs disappeared overnight.
This question was where the developer resides, though. And does that make a difference where the actual development work is done?
Good question. Does it make a difference where the actual development work is done? Yes, it does. So typically over the past year, there were various large law firms and Big Four accounting firms that were directing their ICO clients to offshore jurisdictions. Dozens of them went to the Cayman Islands, and Cayman made it very easy for them to get work permits so their developers could spend time there. That Cayman has a special, economic zone where there were, rooms with cubicles where, developers could go and work unless they wanted to have, a dedicated office, whatever. So all of those factors, but once again, this harkens back to Giovanna's advisory that we're not giving legal advice. And so everything I just said is simply telling you some of the trends in the past, and I'm not your lawyer. I'm not giving you legal advice about what to do or how to do it.
Yes.
Quickly, two questions actually related to some of the points you mentioned earlier. So number one is smart contract. What is, you have seen sort of general legal sort of recognition or its legality, enforcement capability in terms of overall the legal structure. I mean, people see smart contracts as contract. Are they really treated as a contract, bindable contracts? Number one. Number two, related to the ICOs, say if a project company has this, the smart contract and tokens launched, and if for non-malevolent reasons there are problems within the codes, and so contract got hacked and tokens got stolen, in this case, I mean, the contract is supposed to be run in the community, right? So who should be held accountable for the loss of investors' money?
Okay, so the question is twofold. One is, what's the legal status of a smart contract, its enforceability under law and so forth? And second, who's accountable, let's say if there's a hack in the process of an ICO and millions...
Or after,
or
in the safeguards of the proceeds of the funds actually got proven. It's like a doubt, right? But you cannot really reverse the entire process in what they have done in the doubt process. And what sort of project companies should be held accountable, or anybody will be accountable.
Okay, so I'm going to address the questions one and then the next. Legal status of smart contracts goes to an issue that actually I did not touch upon, but it's probably the most important issue in ICOs, so I'm glad this brought it to mind, which is avoiding fraud, okay? If you look at what the SEC has been doing, they've primarily been going after ICOs that they accuse of fraud, okay? Now, with a smart contract, you are basically advertising to your purchasers that everything about your token sale will proceed according to the smart contract. And as long as it does, then you are honoring your commitments. But if you were, let's say, to make your smart contract available on GitHub, everyone sees all the content and the code of it, and then you decide, oh, we're going to do things differently. That would raise a vulnerability from a fraud perspective if your purchasers are harmed in any way, okay? Because the representation of a smart contract is it's immutable. It's on the blockchain, okay? Secondly, in terms of accountability, anytime you're raising funds in any way or selling something, and something goes wrong because of, certainly because of your negligence, then you're accountable. But also in a commercial context, there are implied warranties. So that even if you're not negligent, but someone hacks, you're likely to be accountable. And the SEC is going to see one of its most important functions is making purchasers whole, okay? So if you look at the Texas case that came out in public this morning, Arise Bank, I would expect that one of the things the SEC will do is to take the $600 million that has been raised and distribute it back, first making United States purchasers whole, right? And then, since it was conducted by a company from the US, making other purchasers whole as well. So where does that money come from? It comes from money that until this morning was considered certainly by the founders and the operators of that ICO to be Arise Bank money and under their control. Suddenly, it's not because of exactly the accountability consideration under the law that you asked about.
Yes.
How can you legally convert cryptocurrency as a company to fiat money to finance company growth?
So the question is how you could,
Yeah, after ICO, when you raise Bitcoin,
Yeah.
Ethereum, and other altcoins, how can you legally convert this into fiat currency from dollars and euros to finance company growth?
so the question is after the ICO, how can you legally convert the cryptocurrency that you raise to fiat?
Typically through exchanges, and exchanges have processes basically called know your customer processes and anti-money laundering processes that you need to go through. So they'll typically want to be assured about what your company is, who runs it, what are its key characteristics, finances, sources of funds. So you go through a clearance process with an exchange, and once you do, then you're able to convert crypto into fiat at least to some extent.
Yes.
You mentioned that private ICOs are receiving less scrutiny than, let's say, a public ICO earlier in your talk. How are you defining the difference between, say, a private placing and a public offering?
Okay.
Say at an IPO, for example, that's initial public offering, but it's almost always accredited investors who are taking the side of that IPO. So how are you defining the difference between this private placement of an ICO that's receiving less scrutiny and any other way of performing that ICO?
Okay, so distinction between a private placement and a general solicitation or public offering. There are two main factors or two main vectors to be aware of. One is whether purchasers are limited to only accredited investors, okay? The other vector is, do you do a general solicitation, in other words, public advertising, or do you do only private approaches to individual accredited investors? So I wouldn't say necessarily that a private placement necessarily gets less scrutiny. It's more that a private placement, if scrutinized, will be allowed by the SEC if it fits into one of the exemptions or exceptions to the registration requirement. So one of those exceptions, so let's say the SEC decides your token's a security, okay? If you have limited the sale to accredited investors, you might and probably will be okay, all right? One way that you're okay.
No matter how you market.
Well, that's what I'm getting to. There are two ways. One is you can be okay if it's accredited investors only and you have done only a private sale, not general public advertising, not a general solicitation as you would, let's say, if you did it over the internet. The second way you could be okay is under the safe harbor set up by the Jobs Act and recent SEC regulations, where you need to take reasonable steps to verify that each and every purchaser is an accredited investor, okay? And if you do that and you follow all the required steps for that safe harbor, then you can do a general solicitation, at least in the US. In other words, you can advertise over the internet and say US purchasers may buy, as long as they follow the following process for verifying that they're accredited investors.
The issue with the Massachusetts state coming down on the one ICO, they didn't do either of those things.
That's correct. So they were generally soliciting, or they were doing general advertising in Massachusetts to the public, more than just to accredited investors. And they were not taking reasonable steps to limit the purchaser group to accredited investors, as proven by the investigators successfully registering on the white list or whatever they needed to do to qualify to purchase tokens, and they were able to do it even though they were in the US.
So we need to wrap things up, so we're going to just take one more question. Go ahead. Sure.
So how are the accredited investors that purchase on a private placement limited on the secondary trading? Is there any limitation?
That's a great question. Is there any limitation so that in the secondary markets, when a token gets listed on an exchange, only accredited purchasers can purchase? Okay, so typically what happens is private sales are done with SAFs. The SAFs are not transferable for a period of time, and in a private placement, that's typically the case. However, when the tokens are issued, that's a different thing from the SAF, and typically the tokens then trade, okay? So then you have the question, are the tokens a security? Are they trading despite not being registered? And that's a big issue, and because it's a big issue, you can bet that over time, the SEC will put the squeeze on exchanges, okay? First of all in the US, and then probably in other countries that are responsive to US guidance and or pressure.
So, but are they limited on, okay, so you said that SAFs are not tradable.
Yes. Okay.
Great. Well, we'll take the rest of the questions offline, and thank you all so much for coming.
Thanks.
All righty.